Hi, this is continuation from the previous section on chapter 4, agency representation. So we're talking about who the principal is, and especially around the principal-agent relationship and some of the duties. So essentially, for agency purposes, the principal is an individual who authorizes the agent or brokerage to act on his or her behalf in an agency principal-agent relationship. A principal-agent relationship is created by express and implied agreement by or by law, whereby one party delegates the transaction of some lawful business with more or less discretionary power to another who undertakes to manage the affair and render an account thereof. Duties in terms of indemnity and remuneration. The primary duties owed to an agent by principal are remuneration and indemnification. In terms of remuneration, the principal is obligated to pay the agreed upon amount with where no specific agreement exists. The agent is entitled to a reasonable sum based on the compensation for similar services within that particular locale. The principal must also provide indemnification in respect of all acts undertaken or liabilities incurred by the agent, provided that the agent has acted competently and within the lawful instruction of that principal. Since Now, in terms of indemnification or indemnity, the obligation to indemnify involves the assurance of the one party to make financial compensation or repair and make good of any loss or damage that has been incurred or may be incurred by on the another party. Alternatively, the right of one party to claim damages against another. The specifics of the indemnity are often detailed in an indemnification agreement between the parties or a clause set out within the contract between the parties. Indemnity by principal. The principal must indemnify the authorized agent against losses, liabilities, and expenses incurred in the lawful performance of the undertaking. The agent must have acted within the authority granted. The principal has no duty to indemnify an agent who acts unlawfully or negligently or is in a breach of a duty. Indemnity by the agent. The agent is liable to indemnify the principal for any act undertaken personally or delegated to that agent's employee, salesperson, or sub-agent. The principal may be liable to a third party for the act carried out by the agent under the doctrine of vicarious responsibility. Principal will then claim the indemnity from the agent, who will be responsible for all losses resulting from the breach of the duty. The third party may claim compensation that includes legal costs. The principal may recover monies paid out, legal expenses, and interest on all such payments. Real estate practitioners, in carrying out their function, then encounter various situations that can give rise to litigation involving indemnity or representation made on the behalf of a client, failure to correctly carry out duties in the listing and the marketing of property, the matters involving the drafting and presentation of an offer. Remuneration. Remuneration: an agent is entitled to pay for services rendered as agreed between the parties. In a real estate transaction, this normally takes the form of an agreement, such as an exclusive listing agreement or a buyer agency agreement. If no agreement exists, but the agent acts on the behalf of the client and fulfills the duty that is ratified, the agent will be entitled to remuneration subject to the compliance with the applicable Provincial Real Estate Act. A finder fee. A finder fee is paid to the person or the entity for information that initiates a business transaction. Various types of finder fee or referral fees can be generated from a real estate transaction. The most common in real estate are selling properties and arranging financing. The Code of Ethics and the Robert 2002 federal guidelines concerning disclosure of such fees or the money is paid other than from the client. Remedies. Remedies available to the principal in the event that an agent does not carry out his or her duties, would include dismissal, damages for the breach of contract, action to recover property in the agent possession, action for accounting for all has been received on the principal behalf, action to resist payment. So to rephrase, the remedies available to a principal in the event that the agent does not carry out his or her duties include dismissal, damages for the breach of contract, action to recover property, property in agent possession, and action for an accounting of all that has been received on the principal's behalf, action to purchase this payment, refuse to pay commission, prosecution, and indemnity. The final remedy be a special mention. The agent can be liable to indemnify the principal for any action undertaken personally or delegated to employee or sub-agents when the agent does not carry out his duties, while the principal may in fact be liable to a third party for such acts. Doctrine of fiscal responsibility. The principal will then claim indemnity from the agent for all losses flowing from the breach of duty. As the example shows, the principal may successfully pursue remedies regardless of whether the agent relationship was formally agreed or documented between the parties. So moving to the next item, which is authority. So, authority is the legal power or other right given by the principal and accepted by the agent to act on the principal's behalf in the business transaction with a third party. The listing agreement is the most common form of authority delegated to the real estate brokerage. Wording for this authority vary, as no standard form prevails throughout the province. However, most set have similar basic responsibilities concerning the marketing of the property, payment of commission for a sale, lease, exchange, or option, and authority to cooperate with other brokerages. A typical introductory wording of exclusive listing agreement will be something like, I, seller, hereby give you the exclusive and irrevocable right to act as my agent to lease or sell the property until 11:59 p.m. of this day for the price of this Canadian dollars and upon terms particularly set out herein or at such other price or terms acceptable to me. It is understood that the price set out above is at my personal request after full discussion with your representative regarding potential market value of the property. Most listing forms then detail various responsibilities and obligations flowing from this authority, such as commission payable for the marketing of the property on terms and conditions as set out in the listing or otherwise accepted, agency relationship, including the right to cooperate with any other brokerage, referral of inquiries by the seller from any source whosoever to the brokerage, permission to show prospective purchasers and market the property, including the placement of a for sale sign. Estoppel. Estoppel is a bar to alleging or denying the fact because of one's own previous action or word to the contrary. The concept of apostle comes into play with an agency relationship and authority granted by the principal. Such a relationship can arise when the person conduct is such that that another person is acting upon a reasonable inference that the relationship exists. The person is then stopped from denying the relationship. The relationship cannot be denied if it was a person's own conduct that led to the reasonable but inaccurate conclusion. For example, a principal may be stopped because the principal conduct of allowing that person to be his agent prevents the principal from denying the fact that he or she gave the authority. Apostles may also arise when no actual authority was given to the agent and only limited authority was given authority has been terminated, but circumstances lead to others to believe that the agent has had the full authority. This gives the agent an apparent or ostensible authority to act. The principal will be bound by the contract made with a third party who acted in the good faith. The apparent authority that an agent may have in a specific instance will depend on the nature of the business involved, local laws, and trade customs. For example, a merchandising agent who has possession of goods may have the authority to pledge them for credit. A stockbroker may be able to borrow against bearer certificate in her possession. A real estate broker in some jurisdiction may be able to sign an agreement on the behalf of the seller. However, a real estate broker is usually empowered to trade in real estate by assisting in the formation of a contractual relationship between seller and buyer. This apparent authority is not as extensive as that of other types of agents. Ratification is the process in which the person may initially purport to act for someone as his or agent, knowing the authority to do so has not been granted, or that the limit that the limits of the authority have been exceeded. The subsequent adoption of the agent's action by the principal is called ratification. The transformation of the conduct of the agent after the fact is usually considered to put the parties in the same legal position as if the agent always had authority to represent the principal. Certain conditions must exist before the doctrine applies. The principal must have been in existence and capable of adopting a legal contract. The principal must have been in the contemplation of the agent, and the relationship must have been disclosed to the third party. The principal must be aware of the act of the agent and adopt them unconditionally. Although these rules generally apply, exceptions can exist. For example, in a common law, a limited company does not normally become a legal person until it is incorporated. It therefore cannot ratify an act purported made on its behalf before it was created, unless statutory law provides for this eventuality. In Ontario, the situation has been altered by statute so that a company can adopt a pre-incorporation contract made on its behalf. The wordings used in the typical contract are acts as trustee only on the behalf of the company to be incorporated. The efficiency and speed by which the Ontario numbered companies can now be created, sometimes in one day, has also largely eliminated certain underlying concerns. Express authority. An express authority is a precise instruction, either in writing or orally, in which an authority is granted. In real estate terms, express authority usually applies to listing situations. An authority delegated by the principal clearly set forth in an exact plain direct and well-defined limits those acts and duties that the agent is empowered to perform on the behalf of the principal. If there is a definite understanding between principal and agent that the agent's relationship has been established by express agreement, this may be in oral or in writing or in writing on a seal. An exhaustive listing agreement between the owner of the real estate and the real estate brokerage is an obvious example of the written express authority. Exclusive authority. An exclusive authority is the one in which the brokerage has the exclusive right to sell, lease, or exchange the property owned by the other for a fixed period of time. An exclusive authority is granted to the real estate brokerage named in the listing agreement. The MLS exclusive listing agreement has a similar wording but provides an additional authority for the brokerage to cooperate with other brokerages who are members of the real estate board or otherwise defined to assist in the marketing of the property. The authority, along with the other pre-printed clauses within the listing agreement, normally provides that all marketing of the property, negotiations with the seller, and other matters relating to the marketing process be conducted through an exclusive agent until expiry of the listing. An exclusive authority is contrasted with a non-exclusive or open listing in which any number of brokers may be involved in the marketing of the property, with a commission paid to a successful brokerage upon an agreement being signed and the completion of that sale. The increased use of buyer agency representation in real estate transactions has given rise to an exclusive agency relationship with the buyer. Wordings of both listings and the buyer representation agreement vary by real estate board agreements. Now, There is a listing agreement followed by a buyer agency agreement and option to buy or option to buy or purchase. A listing agreement is an oral or written agreement under which the owner appoints a real estate brokerage for a designated period of time to sell, lease, or exchange a property based on the owner's stated terms, and under which the owner agrees to pay the brokerage a commission. The listing agreement performs several basic functions as the basis for the agency relationship between seller and the real estate brokerage. The the listing establishes well-defined limitation on the agent's authority and provides detailed information regarding the property for assistance when answering inquiries from a prospect buyer. This listing agreement also provides the foundation for offer negotiation, the drafting of an offer, and if necessary, a mortgage application. Most listing agreement consists of two essential parts. The authority provides the appointment of the agent and includes the agreement to pay commission. The data input form provides detailed information on the property. A seller property information statement may or may not be used in conjunction with the listing. The agency and the care in completing a listing agreement are crucial. The listing agreement is a legal document and must be completed with due regards and consideration for its completeness and accuracy. Holdover provision. The holdover provision is a provision in an agreement remaining for a former period and is bound to practically all listing used in the real estate brokerage. Under this provision, while the listing brokerage authority ends upon the expiry date, if the brokerage introduces a person to the property during the term of the listing who affects a private sale with the owner during the specified period after the expiry, the owner is liable for commission payment to that brokerage. A similar provision is included in which a buyer agency agreements concerning property introduced to the buyer during the currency of the agreement. So to recap, a holdover provision is a provision in an agreement remaining for the from a former period and is found in practically all listings used by the real estate brokerage. Under this provision, while the listing brokerage authority ends upon the expiry date, if the brokerage introduced a person to the property during the term of the listing who affected a private sale with the owner during the specified period after the expiry, the owner is liable for commission payment to that broker. A similar provision is included in the buyer's agency agreement concerning property introduced to the buyer during the currency of the agreement. The exact wordings and time limit of the holder method in a listing or a buyer agency agreement can vary. Buyer agency agreement. Buyer agency agreement is an oral or a written agreement in which the buyer typically appoints the real estate brokerage or for a designated period to locate a property meeting a certain general characteristics for which the broker receives a commission either from the listing brokerage or the buyer. Wordings and the terms will vary in the marketplace. Buyer agency agreement performs several functions. The agreement establishes agent authority, commission agreement, agency responsibilities, and other relevant items, including the buyer's obligation to refer found properties to the agent. The agreement provides the foundation for negotiation of a drafting. The buyer agency agreement as a legal document must be accurate and completely prepared, setting out the exact understanding of the client and the agent. Option to buy or lease. An option to buy or purchase is a right given by the owner of the property to another for a valuable consideration to buy certain property within a limited time at an agreed price. The option to buy, referred to in some jurisdiction as an offer to purchase, allows the seller and the buyer to enter into an option that gives the buyer the right to buy the seller's property at the agreed price at some future date. The option to buy is not normally used in a residential transaction, but would have application for transaction dealing with industrial, commercial, and investment properties. For example, a developer wishes to option certain land for a period of time to obtain development approval or adjoining land. An option to buy is distinct from an agreement or a contract in that the latter creates immediate mutual rights and obligations for both buyer and seller. The option to buy only gives the buyer the right to purchase the property within a specified period of time without imposing any obligation to purchase. The option is not to be confused with a conditional contract. one that depends on the occurrence of some future event. When the condition is inserted in the agreement, the court had determined that the obligation exists for the party to make a reasonable effort to satisfy the condition. The option to purchase gives the buyer the right to purchase, but does not impose any obligation to do so. If the option is not exercised, the contract will be at an end. The option is exercised by the buyer, then the binding agreement. If the option is exercised by the binding agreement will result. The seller must understand that while the option period is in existence, he or she cannot sell the property to third party. All terms of the option to purchase must be completed in the same detail as the one would with any agreement. About 2002, the Real Estate and Business Broker Act 2002 and the regulation uses the term representation and make no reference to agency as described in the common law. Selected sections from the Report 2002 are like below. Agency. The common law term agency and necessity terms agent-agency relationship and dual agency do not appear in the Act nor the regulation. The legislation focuses on representation and agreement between brokerage and buyers and sellers. While Report 2002 does not explicitly define the term represent, it generally applies to situations where brokerage owes fiduciary duties to the client. As such, the brokerage must act in the best interest of that person when providing advice and services, as in the case of representation agreement. The legislation also clearly differentiates between a representation agreement involving a client and a non-representation, non-fiduciary customer services offered to a customer by the way of a service agreement. An agent which is derived from a common law does not appear in Robert 2002 or regulation. Registration categories under Robert 2002 includes brokerage, broker, and salesperson. As background, an agency relationship is established between when an agent accepts responsibility to act for another in negotiation with the third party. Buyer representation agreement. A buyer representation agreement involves a written oral or implied agreement between the brokerage and the buyer, in which the brokerage represents the buyer as a client, leading to a trade in the real estate. The Code of Ethics requires that such an agreement must be reduced in writing, signed by the brokerage, and submitted to the buyer for signature prior to the buyer making an offer. The code does not require the buyer's signature, but registrants need to be aware of the practical issues and risks associated with an unsigned representation agreement. Code of Ethics also refers to an agreement registrant have with the buyers or sellers as agreement for purpose of trading. I think with this we are done with chapter 4. Thanks. I think it's better to recap since this chapter was broken into two. So agency has evolved over time as a part of common law. The term agency is not used in regulatory purpose in Rabba 2002, which refers to representation. The principal agent relationship is most commonly established by express agreement. Type of agency includes buyer agency, dual agency, seller agency, single agency, and sub-agency. The agent is authorized by a principal to represent that principal in business transaction with another party. For agency purposes, a principal is an individual who authorizes the agent to act on his own behalf in the agency relationship. The principal duty is owned by the agent. Owned to an agent by principal are remuneration and indemnification. And the authority is a legal power or the right by the principal and accepted by the agent to act on the agent's behalf in the business transaction with a third party. Authority is usually granted by express agreement, but may also be created by apostle, by ratification, or by the operation of law or by implied authority. Listing agreement and buyer agency agreement, not referred to as by representation agreement, both establish appointment of the agent for differing objectives. Never to turn to use the word representation and more make no reference to agency as described in the common law. I think with this we are done with chapter 4. Thanks for your time.